Hello, everyone. Corliss here speaking.
Hello, Corliss.
Good evening. I think everyone from Dentons, East Africa Law Chambers has logged in.
Yes, we are just waiting for a few members to join. Right now, we have only 16 people in total. So once we have, because we given time 6:30, so once we have sufficient number, we can start.
Total number of members who have registered is more than 70. So
Okay, all right, that's clear.
Yeah, we're just waiting to few members to join, then we can start.
Okay.
I think this is because of the time change. People must have not seen.
Yes, actually.
Manishji, so I'm asking, is it going to start by 6:30?
Yes, sir. We have given the time of 6:30 to everybody. Earlier it was 7, but later on we have preponed it by 30 minutes. So we are going to start by 6:30.
Okay, fine. Okay, thank you.
Ouch, thank you. Zoom meeting भी connect कर दे तो battery ना से connect करवाएगी. I know, but Jiten, can you relax instead of being hyper all the time?
Haji Manish ji. Manish ji, please record the on.
Yes. Done.
Yes. So the important topic of BRELA, disclosure of beneficiary honor. So for that topic, we have our eminent speaker from Dentons, East Africa Law Chamber. There are 3 associates who's going to present today under the guidance of Miss Stella Ndikimi. She is the managing partner for Dentons East Africa Law Chamber. And the associate going to present today is Emma Kimario, Isaac Lupi, and Corliss Kidaha. All three are the associate on the Dentons East Africa Law Chamber, and they 3 are looking this corporate commercial lawyer and wide range of experience in handling matter of merger, acquisition, banking, finance, oil and gas and mining. So I welcome all the speakers to present their presentation and go through the requirement for beneficiary ownership under BRELA. Miss Eva?
Beneficial ownership. We have to do it. I don't know how to do it.
I have given you the access of the cohort, so you can present your whatever you have the presentation, and so you can.
Yes, yes. Miss Eva, can you unmute yourself?
FK Chamber lawyer.
Hello, everyone.
Yes, yes, Corliss.
Thank
Can
you.
you open your can you open your camera?
Yes, sure. Thank you for that amazing introduction. Please allow us to share our presentation shortly, and we'll go through it together.
I think you get this co-host, so you can show your presentation by sharing a screen.
Yes. Okay. Can everyone see the screen?
Yes, Corliss.
Yes.
See your screen.
Okay.
Huh? Sorry.
Corliss, can you unmute to start this? Yes.
Yes.
Now it's fine.
So today we're going to give a brief insight into the concept of beneficial ownership in Tanzania. To start off our presentation, we're going to provide how the concept came to be in Tanzania through the changes in law that recently happened. And then once we have grasped that, we'll proceed with the rationale behind the enactment of those laws and why they were brought into Tanzania. And then we'll have a discussion on who qualifies as a beneficial owner in Tanzania and the duties of these persons, or their company secretaries, or their legal advisors. And then finally, we will conclude with what you need to do next. But for now, we suggest that you keep your questions and you save them through the Q&A session at the very end. And we will have our team members introduce themselves.
My name is Emma Kimario, an associate at Dentons East African Law Chambers.
Welcome, Emma, to this webinar.
A very good evening to everyone. My name is Isaac Lupi, and I'll be part of the team that will be presenting today on beneficial ownership. I'm happy to be with you today.
Good evening, everybody. My name is Stella Ndikimi. I'm part of the Dentons East African Law Chambers team that's working on this project. We are happy to be sharing these moments with you and look forward to an interesting discussion.
Rest.
Members, they all are please requested to mute yourself so that there will be no disturbance from our side.
Stella, you're most welcome for joining this session.
Thank you, Damindra.
I think this presentation is gone, I think. Some issue with
Okay, I think everyone can see the screen now.
Yes, please.
So just to provide a background, initially, the concept of beneficial ownership starts off from the landmark decision by the House of Lords in the UK in the famous case of Solomon and Solomon. This is a very old case that introduced the doctrine of a corporate personality for an entity, and it also has been recognized in Tanzanian law. So this doctrine provides that a company is a legal entity which is separate and distinct from its shareholders, directors, as well as its employees. And in essence, this limits the liabilities of shareholders from the obligations of the company by creating what is known as a corporate veil between the shareholders and third parties who are dealing with the company. So essentially what happened in Tanzania is in the Finance Act of 2020, it introduced changes to the Companies Act, as well as the Trustees and Corporation Act and the Anti-Money Laundering Act and the Income Tax Act by establishing beneficial ownership rules. And the beneficial owner is something that is not new in Tanzania in terms of the tax realm, because it is featured in the double taxation agreements to which Tanzania is a party as one of the conditions which must be satisfied before a claimant can qualify for tax benefits. So our laws essentially started off with the Finance Act, but then this transitioned into a separate regulation solely dedicated towards beneficial ownership, which was the company's beneficial ownership regulations, which came out mid this year, and which required that every company which is registered under the Companies Act to submit their particulars of their beneficial owners to the Registrar of Companies. So the Registrar of Companies is the same entity that governs beneficial owners. Locally, this is known as BRELA, the Business Registration and Licensing Agency. So now, why was this concept brought into Tanzania? It was already in the tax realm, but the finance bill, before it came into effect, provided clearly that the essence and the rationale behind introducing beneficial ownership was to help to ensure that for tax purposes, the right people are being taxed, and also to control transactions that are contrary to the Anti-Money Laundering Act, as well as prevent terrorism financing. This stems from the misuse of the doctrine of corporate personality, which we just spoke about, and the corporate veil for purposes of tax evasion, money laundering, and other illicit practices that have grabbed the attention of various regulators and policymakers around the world. So to counter this practice and these illegal activities, the regulators have established these transparency rules to identify beneficial owners of companies, trusts, and other legal arrangements. So from the provisions of the Tanzanian Finance Act of 2020, Tanzania has followed suit. However, in the Finance Act of 2020, it is evidently intended to identify ultimate beneficial owners of Tanzanian companies and trusts for the purpose of preserving the integrity of the tax system, including identifying treaty shopping arrangements and increasing transparency and information sharing between the regulatory authorities in combating money laundering and terrorism financing. So we can see it clearly opens the door between regulatory bodies to converse with each other and identify who these individuals are. My colleague will move on to the next part of the presentation, answering the most important question, which is who is a beneficial owner?
Thank you very much. Thank you very much, Collis, for the very good introduction. So we are now going to see who is a beneficial owner. Easily put, a beneficial owner is the person that ultimately benefits from the proceeds of a company. It is understandable that there might be shareholders of a company who are natural persons, or I mean human beings, and there could be the shareholders of a company who are companies as well. So when speaking of beneficial owners, as it is displayed on the screen, this means a natural person, a human being who ultimately owns or exercises substantial control of an entity. So this is to say simply that beneficial ownership is all about the human being who enjoys or who reaps off the benefits of a company. So this could be directly that I'm directly a shareholder in a company. So I am a beneficial owner in the company. So again, there could be arrangements whereby I enjoy the benefits from a company, but I do not appear in the books. I'm off books, not appearing anywhere. So in this way, there will be someone who appears in the books on my behalf. And this as well has to be disclosed through as required by the new law that has introduced the beneficial ownership in our jurisdiction in Tanzania, so to say. So this brings us to the big question, as in what are the duties of the company now in disclosing the beneficial owners? The company has disclosed the duty of disclosing who the beneficial owner is rests into the company itself. As my colleague Collis had stated earlier, in the famous case, as she well put it, a company in itself stands as a legal person. It can be sued, and it can also sue on itself. It does not need any other person to be sued on its behalf. So this means that the duty to disclose who the beneficial owners are lies to the company itself. So let's say company X has a duty to disclose who enjoys its ultimate benefit. So the company must as well take reasonable steps to identify its beneficial owners, and it is also duty bound to notify the registrar if there are any changes in the details of beneficial owners. This includes changing physical addresses, or maybe changing control or changing beneficial owners itself. There are circumstances whereby we see a company transfers shares to another company, or an individual buys stake in another company. So all this brings together the duty of a company that it has to disclose every change that it undertakes in the beneficial owners that it has. So we have heard that a company has a duty to disclose the beneficial owners. So what is it that the business registry, BRELA, requires from every company? With the introduction of the new law, BRELA requires from every company to disclose the identification of this beneficial owner, of this person that owns substantial control in the company. It also needs to disclose the place of work. Of course, it's all minute, every detail of this person. How much stake is he owning? How much influence does he have in a company? This all has to be disclosed to BRELA. And much as the law is silent, as in to be disclosed. And by saying who has to be disclosed, I mean that is it every person that owns or gets a benefit from the company must be disclosed with a business registry in Tanzania. The law is silent, it does not bring any exclusion, but engaging with BRELA in different activities, they have set a limit to, let's say, to 25% of ownership in a company, or 25% in ownership of the company, or in substantial control of the company. So currently, BRELA is receiving the information of beneficial owners who own 25 and more percentages of control within a company. So this brings us to the big question. What if somebody owns 3%? What if somebody owns 0.2%? Am I still supposed to be disclosing this person? Yes, the answer is yes. After a certain period of time, BRELA will still come back to us and require us to disclose the information of the minority shareholders. But as the law stands and as the practice is at the moment, only the shareholders or the beneficial owners owning more than 25% have to be disclosed. That brings us to the question and answer sessions, if any. Over to you, Collis.
Yeah, I am Milind Kapadia. I have a question.
We're welcoming anyone who may have a question.
Yeah, can you hear?
Clarification.
Can you hear me? Hello? Am I audible?
We are hearing.
Yes, Mr. Milind, you can ask the question.
Yeah, my question this introduction is done by BRELA, since as all are aware that there are two authorities in Tanzania. One is BRELA and the other is BPRA in Zanzibar. My question to the speaker. My question to speakers, whether is this applicable for Zanzibar companies, those who are registered in Zanzibar?
Corliss, please unmute yourself if you understand the question.
I hope my question is clear.
Yes, the question is clear. Stella.
Miss Stella, you can unmute yourself.
Sorry.
Yes.
Sorry, the question is clear. My suggestion would be maybe to take another 2 or 3 questions, or would you prefer that we answer question by question?
I think you can answer question by question according to the member.
All right. So as you may know, the Finance Act applies to both Zanzibar and Tanzania mainland. And as such, the requirement to disclose beneficial ownership would apply both ways. But we have different registries and different Companies Act that govern these registries. So in as much as this requirement has been introduced by the Finance Act, we do not have a specific law that has been passed as of now, currently today, that would apply to Zanzibar. And therefore, when we talk about the beneficial ownership regulations, those apply to Tanzania mainland and not Zanzibar. But as Collis said, the regulators are speaking to each other And it is just a matter of time before, we see this being applied in Zanzibar as well. But as we speak, the beneficial ownership regulations that are currently in force apply to Tanzania mainland, which then refers to BRELA and not BPRA. I hope that is clear.
Yes, thank you. Thank you very much. It's clear. Thank you.
Dear members, if anybody want to ask any question, you can unmute yourself one by one.
I have the act is that it's the duty of the company to notify the registrar about the beneficial ownership. Basically, the owners to notify the registrar on behalf of company is whom? Either it's a director, or if the director is not in Tanzania. So the acting general manager, finance manager, or basically who is the first person to notify the registrar?
I will take that once again. That the duty, the wording of the law is that the duty rests with the company. And in terms of the Companies Act, the duty to notify the registrar of any changes is a company secretarial, sort of task. So the first point of reference should be your company secretary, who has a duty to notify the registrar of any changes or to submit the information on beneficial ownership. But in the event of a default, any officer of the company would be held liable. Now, who is an officer of the company? Officer of the company are the directors, the company secretary, and any senior management officials of the company. But just to respond to the question, the first port of call should be your company secretary. But in the event of default, then that would apply to any officer of the company.
Fine. So the company along with the directors will be responsible for that.
Just to clarify, any officer of the company, officer includes the directors, the company secretary, and senior managers of the company.
Mr. Pavan, you can ask your question. Chandresh bhai, after that.
Good evening. My question is regarding this oath filing, whether there is any specific format or any legality is required regarding that.
Yes, does anyone from the team want to take that question? Hollis?
Yes, Pawan. So there is a special portal that's been created by BRELA. You can access this through the www.bo.brela.go.tz. It's an online portal specifically for beneficial ownership filing. And the information that is required by BRELA to this effect is identification of the beneficial owners. So this can be a NIDA card or a passport in case of a foreigner, as well as their contact details and details into the percentage of...
Sorry, my question is regarding this oath filing. Oath filing that you are not connected with political party.
Sorry, could you repeat that?
There is a requirement of filing of oath that the person is not affiliated with any political party.
Yes, that is a declaration.
Is there any specific format, or it is just a self-declaration?
There isn't a specific format provided for. So it can be in the form of a declaration where the relevant person verifies that information and provides a statement that they're a politically exposed person.
It is to be certified by any notified or any oath, the registrar has to sign that?
The law does not clearly provide for any attestation or certification by a lawyer, but we advise our clients to do the same.
Okay, thank you.
Thank you.
Hello.
Chandresh, yeah, Chandresh, you can ask the question.
Correct. If you want to know, there is one company, the only holding company registered in other than the Tanzania. The company was listed in Tanzania, how we can integrate the beneficial ownership with the owner of the shareholder?
Carly, you are unmute.
Chandresh, do we understand you clearly that the company in Tanzania has a shareholder, which is another company outside of Tanzania?
Yes.
Okay. In that instance, BRELA will require you to trace back to the natural person who is behind that corporate body outside of Tanzania. So if that corporate body has another shareholder, which is a natural person, that is the person that must report their beneficial ownership status to BRELA. So they trace
Correlate, it is a listed company, so it's a large number of shareholders.
Okay, in the case of a listed company where there's no natural person who holds 25% or more shareholding, then there must be a disclosure made to BRELA informing them that this is a company that is owned by another company that is publicly listed, and therefore we are unable to provide this filing, and then BRELA will provide further guidance. But it is important that the regulator is informed as opposed to not complying.
Then, hope Chandra, you're clear. We have another hand from Mr. Rakesh Kumar. You can unmute yourself.
Good evening. There are two challenges which are coming while uploading this form. First one is the date and place of birth of directors. And now directors are around 70 years. Difficult to find where they were born, area, very difficult. That is first challenge, very basic challenge. Second, there is an option is coming right to appoint. Now there is no any specific thing is what right to appoint direct. While uploading form, their questions come right to appoint. So what right to appoint? Not specified.
Thank you, Rakesh, for the questions. And I got your first question correctly. And you are saying that it is difficult to trace where the directors are born or where the beneficial owners are born. But I could not quite get the second question. If you don't mind repeating the same for me, please.
Yeah, this is question number one. Second question was, when we are uploading form, the one questions came right to appoint, direct and indirect both. But it is not specified what right to appoint.
Thank you, Rakesh. Now I got your questions quite correctly. And I'll be starting with the first question. When I was making the presentation, I said that part of the information that is mostly required is the identification of the beneficial owner. And this is no exception that you have to provide the place where this beneficial owner resides. I've seen the photo. I've been there in quite a number of occasions doing some stuff, and what they require is the place where this person resides at the moment. And ideally the place where he was born, as you are saying. But this information could be received or you could find this information from the biodata page of the director or the beneficial owner. You could get the place where he was born, maybe born in Tanzania or some place of a sort. And there are other places where you do not need to, it's not a mandatory field to fill in these fields. The fields that are mandatory are in asterisk, as opposed to the ones that are not mandatory. So maybe you should do, if it shows that you do not know where this person was born, which ideally a company has to know where this person was born since he's part of the management of the company. But if that is the case, then you can leave it blank.
Okay.
with the second question on uploading the forms, when it states the right to appoint, now this depends on what right to appoint, and as you're saying, it could be a right to appoint directors. There are arrangements in different companies where certain members of the company or certain beneficial owners have ultimate choices to make differences or to appoint people who would be acting as directors. So this depends on arrangement. It differs from case to case. Thank you.
Thank you very much. Thank you.
We have two questions on the chat. One from Mr. Nagaraju. He asked that, is this disclosure is in addition to annual return, even if there is no change between two annual returns? Any specified form for the same? Is it online or offline disclosure?
Thank you, Dharmendra.
Yes.
I'll take that one again. The need to disclose beneficial owners is ultimately a new thing. It's apart from the filing of annual returns. So by saying this, I mean that we have in place the law which provided for the filing of annual returns. And this is different from the law that is establishing the filing of beneficial owners. And this is to say that maybe to shed more light into it, this is to say that there are two registers within BRELA, that one would deal with the normal filings of the company. This is to say the annual returns, the change in directorship, every other stuff. And there is this special registry that has been recently established to deal with beneficial owners. And reading the wording of the law, maybe for the benefit of many, the law strictly prohibits the disclosure of the beneficial ownership information to people who are not required to be getting the information. So the information that is filed, even though it is dealt with BRELA, but this is a separate registry that will be dealing with the same and setting a different requirement from the requirement of filing annual returns. Annual returns are filed annually, but the beneficial ownership information are filed once in a time and at every point in time when a change appears in the company.
Okay, so it is online form or offline form?
Yes, the beneficial ownership information is filed online, but
okay.
Even though it is filed online, you have to fill in the details online, as the previous speaker had asked the question about the online filing. You have to file the documents online, but yet you still have to do a paperwork. You do a paperwork, you fill in some forms, these are prescribed forms, and the same would be uploaded in the due course.
Okay, understand. There is another question from Mr. Helen Kianga. Is the legally executed oath or affirmation on PEP supposed to be attested by any advocate in Tanzania or?
Thank you again, Amanda. I think my colleague Collis had addressed to that the law does not specifically provide that you have to give an affirmation on PEP, but we advise our clients to do the same, because even the forms that I've said, they require you to disclose a beneficial owner. They just state that is it a PEP or a PEP?
Yes, understand. We already reply on this. There is a additional question from Ajmina. What happened when currently you have applied for change of address that is still pending in the system, which now puts a halt on us to submit the beneficial detail? Is there a way around it?
Thank you for the question again. As I initially said, these are two different registries: the registry for beneficial ownership and the registry for the company. If you're making a change of name, this would be on the normal website for BRELA that we usually do the company filings. So ideally, it should not matter, it should not intervene, or it should not make it difficult to file the beneficial ownership returns or information as such. Thank you.
Okay.
Dharmendra, if I may, just to add on to what my colleague Isaac has said, with the beneficial ownership register, it is a confidential register. This information is not publicly available, and the filing of it is also done in confidence. And therefore, whatever needs to be done on a regular basis in terms of the company maintenance, your filing of annual returns, notifying the registrar of any changes in the directorships, and so on and so forth, that is a different registry, information of which is publicly available. With the beneficial ownership disclosures, the information is confidential, and the registry is confidential as well. That register is not publicly available.
So it means
so
that data will remain
to bring
secret.
That out. Yes, it remains secret.
Yes, thank you. Thank you, Mr. Basu. I think your question is answered.
Exactly.
So we have Miss Ajmina. Mr. Ajmina, you can unmute yourself. You can ask the question.
Hi, it's regard to the same question that you mentioned. It was one of my questions. Basically, what's happening currently is we had filed for a change of address, which is still pending. Unfortunately, we can still not go ahead and file the beneficiary documents because of that pending change of address that's still there. We've tried to get in touch with BRELA to either cancel that or so that we could go ahead with this particular exercise before the 31st. Unfortunately, we cannot. So is there a way around it? Because we have tried and we're unable to.
Thank you, Azmina. Again, these are two different registries, two different portals. The filing of a change of address should not impede the filing of the beneficial ownership information. And I guess what that means is that probably you need to have a conversation with BRELA, because the portal that we use for the beneficial ownership information, filing of that information, is not the usual BRELA ORS portal that we've been using for other documents. So if the change of address is not allowing you to file your beneficial ownership information, there should be a problem, which I would suggest you speak to BRELA to resolve. But otherwise, you know, from the way that the two systems are operating, it should not be the case.
Okay, is it possible then to forward us the new portal? Because I have been using the ORS one, and maybe that's the reason why we cannot go ahead.
Yes, ideally you should not be using the ORS portal for filing of beneficial ownership disclosures. And we will share, after this call, we will share a brief email together, of course, with the deck of presentation deck that we have shared with you, explaining how you get onto the portal for filing of it. First, you need to register on the portal, and then BRELA will give you access through which then you're able to file documentation. We will share that information.
Oh, okay, so it's a completely different entity per se that we're going to be using. Nothing to do with the already registered user and whatever details we'd put in on the ORS. If
that is correct, you need to do a new registration. Yes, you need to do a new registration with the new portal.
Okay, thank you very much.
Anybody else have any question? You can raise the hand. Mr. Milad, you can, yes, please.
Yeah, I have a question that in case a company is registered in Zanzibar, but it has a branch in mainland, so definitely they are registered with BRELA as a branch. In that case, is this regulation is applicable?
Yes, Abhishek, it is applicable. And therefore you would need to register for beneficial ownership disclosures.
Mr. Milind, have your question is answered, I think. Now we have Mr. Mahesh. You can unmute yourself.
Yes, thank you very much. I got one circular where it was saying that you need to file the forms 14B and 14E. Now 14E has to be filed by the shareholder to the company, and 14B has to be filed by the company and submitted to BRELA. So my question here is, I mean, the shareholder, the beneficial owner must first file to the company, and then the company will have to file through the portal. So is the same portal going to be used for the both people, or it's only for the company?
Thank you, Mahesh. The wording of the law, as it states, is that I had previously explained the same, that a company has a duty to disclose its beneficial owner. So this brings us to another concept, as in, where does this company get information from the beneficial owner, the information about the beneficial owner? So when you're making the filings online, and when you're filling the form 14E, the form 14B that you have been making reference to, this form, at the very bottom of it, it asks you where you got the information from. Is it from the beneficial owner himself, or is it from an authorized personnel, or is it from a company secretary? So these documents are interrelated. Form 14E would tell you where exactly, would give you the information that you'll be using to rely on the same. So 14E would be brought to the company, and out of 14E, the person who is filing the beneficial ownership would be filing from 14B for onward transmission to BRELA into the portal. Thank you.
Okay, just one thing, just to be more clear, 14E, it has to go through the same portal?
No, it doesn't. This form, yes, it is for the benefit of making known your information to the company. So if I want to be more clear, just to shed more clarity on the same, looking at the form that you're speaking from 14B, it has a place where it indicates as in requiring you to disclose when the information of a beneficial owner was disclosed to the company. So from this information, it's where you put the date where you received form 14E. Let's say you received form 14E on 10th of December. Then when you're filling form 14B, you'll be writing that you received the information about the beneficial owner on form 14 or on the 10th of December. So just to cut the long story short, the information that you receive from form 14E, that is for the internal use of the company, and it will be kept in confidence within the company. What goes out to BRELA in confidence again is form 14B. Thank you.
Thank you, Lupi. Thank you.
Can I?
Yes, Yes.
Yes. Just wanted to know, I just asked a question that the branch of a company registered in Zanzibar having a branch in mainland, under which section is this applicable? Can you give me the section reference, please, if possible?
Thank you, Kapadia. Maybe I'll be sharing this section later, but just to shed light on what Stella, my colleague, had previously said, is that the Companies Act, the beneficial ownership was enacted by, or was brought into action by the Finance Act, which applies to Tanzania mainland and the ISOs in Zanzibar. That means every company that is registered in Tanzania mainland, even if it is registered as a branch, this company, it is doing business and it is within the register of companies in Tanzania mainland. That means it is regulated under the Companies Act of Tanzania, Cape 212. So this being the fact, the regulations that govern beneficial ownership are made out of the amendment to the Companies Act that takes precedence or applies in Tanzania mainland. So this company that is a branch in Tanzania, it is obligated to file its beneficial owners since it is operating under the laws in Tanzania mainland, even though it has its shareholders and its beneficial owners in Zanzibar or in another company that is registered in Zanzibar. So this would be bringing us again back to the question that was asked by Chandresh, I guess, that where you have a company that is existing in Tanzania mainland, but still some of its shareholders are foreigners, you still have the duty to disclose the same. So you'd be having to disclose the beneficial owners that are originating from Zanzibar for the company which is operating in Tanzania, just as you would to any company that is located in Tanzania. Thank you.
And to add up to what my colleague has said, I would like to refer you to Regulation 3 of the Beneficial Ownership Regulations, which says a company incorporated or registered under the Act shall submit to the registrar particulars of its beneficial owners in Form 14B prescribed in the company's forms. So it's Regulation 3, and it says for a company incorporated or registered under the Act. If that answers more your question.
Right, thank you so much.
Ms. Seema, we have two questions on the chat. One is that if there is more than 2 shareholders who hold more than 25% shareholding, so we need to file both of them as a beneficiary owner?
Yes, we need to file for each because the law wants to know the natural person behind each more than 25 shares and more shareholding. So,
okay.
Yes.
And if the company is limited by guarantee, then also we need to file this because in that case, there is no shareholding.
The law applies to both public and private companies. It does not.
Oh, no, I'm asking the company limited by guarantee, not by the shareholding.
Yes, Damindra, it would apply to companies registered, limited liability companies, limited by shares, as well as limited by guarantee. In the case of companies limited by guarantee, you would be providing information of the contributories of those companies or the guarantors as we refer to them. And to just provide a little bit more clarity on the 25% requirement, this is only applicable, at least from our engagement with BRELA, where the holding companies are listed companies, where it is difficult to trace the shareholding to a few individuals. Where the shareholding is held by just a handful of individuals, you have to disclose those individuals and the shareholding that they hold. But for listed companies, where you have thousands and thousands of people for listed shares, and where shareholding changes with every minute as the stocks are trading, BRELA's position is that in that case, we need to disclose shareholders who hold 25% or more, and where you do not have that in a few or one shareholder, then shareholders who in aggregate hold not less than 25% shareholding. So you would need to look at, what the structure of the companies are, and either decide to produce the information of either a few of the shareholders who in aggregate hold 25% or more, or if you have a few or one shareholder holding 25% or more, then you would need to disclose that information. But as my colleague Isaac had explained earlier, the requirement is to provide information for each and every beneficial shareholder. This exception on the 25% is only applicable because of the challenges that arise with listed companies, and therefore we need to be careful with that.
I understand. Thank you so much. Anybody have any question? I think we have replied all the questions.
Like initially, we are going to file Form 14B, beneficial ownership of the company. Later on, if there is any change in those beneficial ownership, we are going to file Form 14C. And in case if there is a restructuring, addition of share capital, reduction of share capital, anything else, we are going to file Form 14F. Now, my question is, once we file the Form 14B, say whose due date is 31st of December this year, and after that, there is no change in the beneficial ownership. So do we need to file the same form every year like we are filing our annual return at the anniversary of the company? Like the annual return currently we are filing on every year at the date of incorporation of the company. So same way, do we need to file this Form 14B also every year in case there is no change on the beneficial ownership?
According to the law, you'll only need to file when there are changes. The moment you disclose, you have discharged your obligation, but when there are changes, you'll be required to file Form 14E.
No, 14E, which I understand is basically the declaration from the shareholder to the company.
Yes, so if there are no changes, no further filings would be required. You will only need to notify in the first instance, where the deadline is 31 December this year. After that, if there are no changes, there's no obligation to file on an annual basis. But when changes occur, you will need to notify the registrar using the prescribed form.
Within 30 days from the change, which the law says.
That is correct.
Thanks, Stella. Mr. Bhupendra.
रजी भाई ये कौन सा फॉर्म है? ये सुविधा डिफरेंट है क्या? मैंने वही भरा ना? हाँ, ये सुविधा हमने भर दिया. तो इसमें पेमेंट का ही पूछता है.
I think we have clear all the question. Mr. Manish, you can go ahead with the thanks note and this certificate of appreciation. This was very nice.
Thank you. I can see a question on the chat. There is a question there from, I think, Tina. She's asking Tina, if the company has authorized share capital of, I think that's 10,000 shares, but only 100 shares have been issued. The question is, does this also qualify for beneficial ownership submission?
Yes.
Of course, the answer is yes. For the 100 shares that have been issued, you need to disclose the beneficial owners for those. Any shares which have not issued, obviously they're not in anybody's hands. No action is required for those. But for the 100 that have been issued, you would need to disclose who are the beneficial owners behind the 100 shares. I'm not sure if that answers your question, Tina.
Yes, she's.
Yes,
thanks. I can see it's clear. Yes.
Thank you, Ima, for this wonderful presentation. I can see the number of participants on this. Like earlier, we used to have only 30, 40, but due to this hot topic, we can see the number of participants more than 65 who have participated. And I can say like 95% of the participants who have registered for this event, they have attended this event. And the way the question and answers are there coming and the involvement of the member, you can see like everybody is much aggressive and interested in their question. So thank you, Ima and his team, Isaac, Stella, and Torlis for giving you a wonderful presentation. And as a token of appreciation, we are presenting you our digital certificate. Thanks a lot for giving your time and handling all the queries from our members.
Thank you very much.
Thank you very much.
Thank you very much.
Thanks a lot.
Thank you all.
On behalf of our team, may I take this opportunity to thank you as well for giving us an opportunity to make this presentation to you. As we promised, we will make the slides available to you, as well as share the link to the beneficial ownership registration portal. And if you have any questions, please feel free to reach us on an email address that will be included in the slide deck that we're going to share with you. Thank you so much for your time, and we hope to see you some other time.
Thank you so much, Stella. Thank you so much for your support and stand on this. Thank you. We have a lot of questions. We never see such long questions.
Thank you.
Thank you.
Thank you very much. And with your permission, Demindra, we can leave the call.
Yes, please. Thank you so much.
Thank you very much. Have a good evening.
Thank you all. Bye.